Oh, that's it. Hey, here we are.
Hey, we are live.
Oh, I want to suck your blood.
That's my real
Oh
face.
my
But
goodness.
all right.
That's yes. Now
That was
take your mask off, Richard.
Oh, that's a funny one. That's a funny one. Do you want to explain what happened with the penguin?
No,
Okay.
I don't have a penguin for
All
you.
I know, this is the honest truth. I promised a penguin. JR promised to deliver a penguin, and there's no penguin. I'll let you draw your own conclusions.
It's too
So
hot. It's too hot down here for a
it
penguin.
is. It is really hot, and we're like 3,000 miles apart, but it's really hot in this office also. So, not legal advice in JR, or JR and not legal advice, depending on how you look at it. And talking about whatever we're going to talk about here, a bunch of nonsense. Jerkesi, Alpine, our trip to South Korea and Thailand. We're leaving on after this live stream is over.
No, folks.
Oh no, Peerage Capital. Well, you never know, right? You don't know until it's over. It could happen. We might get an invitation. It's possible. The president of South Korea and JR are tight. That's what I know. That's true,
Very
right?
much.
We're going to talk about Peerage Capital because I thought that was an interesting case. The Tesla Cybertruck that JR was just raving about.
Yeah, got one it's out in the garage right
He
now.
does. He does.
First off the line, man.
He's very. I think you're the first one to have one in Hershey, right?
Yep.
Yeah, first one in Hershey, Pennsylvania.
First one in Hershey.
Amazing, amazing. And we'll talk a little about MMTLP arbitration update and some questions from the peanut gallery, as JR would call them.
Yep.
Right. So before we start that, I wanted to ask you a couple questions. These are questions that JR was supposed to have looked at, but he did not. So it makes the answers more interesting. Give me the name of two comedians that you presently really like. I don't mean like personally like them. You like their humor, and exclude me from this category, please.
Well, Ron White has always just made me just laugh. I mean, I love his humor. And is it Bill Barr? I think is his name. Bill Barr. So I love poignant quips about things in society that shouldn't be talked about, because look, humor has always been kind of a way for me to deal with a high stress emotional situation. So I love comedians that look at what's going on in society today, whether it's politics, culture, whatever, and find the raw humor in it. You don't have to like what they say, but the observations and the quips, they're just funny.
Yeah. So I didn't even think about this until you were talking. But when I was in college and probably like a senior year in high school, so I was like 29 at the time. You're supposed to be awake for that, by the way. There was a comedy club in Westwood near UCLA.
Right.
It was a offshoot of the Comedy Store. It was literally called the Comedy Store. So the Comedy Store is like a main comedy club on Sunset. This was the satellite club right next to UCLA, and it probably sat maybe 30 or 40 people. So it was tiny, but it was the comedians of the time really enjoyed playing college areas, whatever. That was kind of their thing. So I remember, and I didn't remember at the time, but I remember it afterwards because we were talking to other people. We saw like Jim Carrey, Robin Williams when they were 20 years. I mean, they were really young and just going out. So that experience, like in a small club where literally you would heckle the guy by talking to him, that was really because you were so close. That was a lot of fun. I remember that. Comedy movies that you like. Give me one or two.
Comedy movies that I like.
Yeah.
Oh, I got to think about that.
I'll,
Comedy
I'll
movie.
give you I'll give you a couple. So my funniest movie I saw at the time, but I don't know if it's really funny, was called Schlock. It was John. Do you remember a director by the name of John Landis?
No.
Okay. Well, then it doesn't really mean anything to you. Schlock, Kentucky Fried Movie, Airplane. Um,
Oh, I know. It just popped into my head. Sorry.
Young Frankenstein.
Young. I mean, I know Airplane, Young Frankenstein, but I think and I don't know. I guess it could be called a comedy. When you said comedy movie, I thought like a rom com or like something like
Did I
that.
say that? Is that what I said?
No, no,
Okay.
but that's what popped into my head. My favorite comedy movie is The Naked Gun 2.5.
Is that the one where OJ goes over the rail? Okay. All
That's
right.
the one with OJ in it.
All right. I remember he that was at Dodger Stadium and he went kind of over the rail. Yeah, that
There's
happened.
just so many good one-liners in that movie.
Yeah.
Is it Leslie Nielsen
Yes. Yes.
yeah,
You know
police,
what's
the
funny
files
is
from the police squad.
the police. What was that? That movie with police was like a whole series of movies.
Yeah, it was police.
Okay. So I forgot the name of the movie, but there was a guy in there, Michael Winslow, who made a bunch
Yeah.
of funny noises.
Yeah.
When I was wow,
Well,
this
you'd
went
have been
kind
in
of
your
south.
you'd have been in your like early 20s when
I
that
was
came
like
out.
about 94, I lived in we were just married. We had one kid, small kid, like a 2-year-old kid, and he lived in the same condo complex. And we would
Really?
have like 8 units, whatever. We would have like a holiday party. You went over there and he was still doing those stupid noises. So it's entertaining, but maybe, amongst the people,
Well, I never liked any of those movies. The Leslie Nielsen one, because Leslie Nielsen was he was like a
yeah, a
real
straight
actor.
actor.
He was a
Yeah.
straight actor, and then all of a
Yeah.
sudden he started. I mean, I just like I'm giggling and just thinking
Look at
about
that.
some of the
They should
lines
pay
in
you
that
some money for this.
movie.
All right. All right. So, okay. How about most oddball movie you ever saw?
Most oddball movie I've ever saw. Well, there's just back in the early '90s when we were out of high school, but before
You don't have to give
we
me
were.
like a
No, I'm just
story.
saying we used to watch cheesy horror movies, and
All right.
so I think the one we watched was it was based on a book by Stephen King called Golden Years, and it was awful,
Okay.
just awful.
Did David Bowie sing the theme music?
Hold on a second. Hold on a second. Dr. Edwards asks, what time does the Eagles defense show up asking for a friend? Now, I find that convenient because Dr. Edwards texted me, when the Eagles were up 6-0 and said, oh, it's going to be a blowout by the Eagles. Now, and you want to crack a joke like that, Dr. Edward? Come on.
Yeah, I have to be honest that prior to our airtime, JR did make a comment about that, just to let you know. So he's at least consistent with what he just said.
Oh, see, Al, they're all showing up now and saying Eagles went to the wrong coast. The game's, first off, the game's not over, but I freely admit I turned it off so that I'm not constantly turning around to see the score.
Yeah, we had a discussion about that. Is I used to love sports a lot. Maybe this is going to be a good, interesting session. I used to love sports, but at some point in time, even the teams that were really successful, it would cause me more anxiety and heartache than pleasure. And it turned me off to sports. So now I could follow the outcomes, but not watch them. So
I'm going to tell you something.
It's sad.
Dr. Edwards
Very
is saying, if you two plan on trolling me because of the Eagles, I got news for you. It's going to be bad. I will hammer you guys when you least expect it in a space. So please be careful.
Yeah. So,
Just
you could hammer them for a lot of other reasons. So, you skip that.
Dr. Edwards keeps telling everybody he's a chiropractor, but
did you answer the question, by the way?
No, I'm sorry. What was the question?
Most oddball movie you ever saw?
Yeah, it was Golden Years. It was a Stephen King. Okay. It was a Stephen King novel turned movie.
So the answer is yes. You answered the question.
Yes, I answered the question.
All right. So mine was, and it's the first movie that comes to my mind when I think of that question. And I wonder if anybody else has seen this movie. Has anybody else seen Pink Flamingos?
I've heard of it, but I don't think I've ever seen it.
Yeah, that's a no-brainer, that one, by the way.
Yeah.
Okay. I was going to ask you if you were ever arrested, but I don't know if I'm going to ask you that now.
No, no, I was never arrested.
I had one fun experience completely, as every defendant ever said, completely innocent. I was once, this to me, it was like a remarkable experience. I actually, and I enjoyed it, to be honest. I was in a local California city. I had a deposition, and I wonder what people are probably wondering how this relates to MMTLP. Yeah, that's true. I was in a Southern California city. I was overnight to do a deposition of a boring tax guy. So it wasn't just a tax guy. It was a
Aren't
boring.
all tax guys boring?
No. This was an exceptionally boring tax guy.
It's like actuaries.
Yeah, I don't remember. It came up. Maybe it was a damage issue or something, a tax issue. I don't even know. And so I was down in this city. I was watching something. I had one drink, literally one drink. You know, in the bars, they used to have those little airplane bottle-sized drinks. You're probably familiar with those airplane.
What are those?
I think it's a 1 ounce. It's 1 ounce. So I had
probably got 20 of them right here in the bar.
I had one, but I had it like 5 minutes before I went out, and I was exploring this city. So I go to a street where I'm not familiar with it, and I hesitate. Cop pulls me over. He asked me, "Have you had anything to drink?" I'm truthful. I said, "Yeah, I had one 5 minutes ago," and he's, what am I going to do?
Step out of the car.
Yeah, step out of the car. He makes me do the the line. So it's at night. Your hands are up. It's like you're doing that thing from Karate Kid. You know, you're trying to balance. There's no way, by the way. I think that would be my legal advice next time. If anybody is stopped and they're asked to do that ridiculous dance, just refuse. Say, I'll pass. I'd like it. But anyway, they did that. I took blood because this is no.
Is this before or after you had your law license?
During, I believe.
Even better.
Yeah. No, I think you have an option, right? You can do different ways of being tested. So if you get tested by blood, it takes the longest for them to get it done. So generally, it'll give you the lowest reading. That's a technical advice there, if you're ever in that point. And then they book you. So I get booked into this jail, right? Are you still listening? Are you still awake over there?
I'm still listening.
I get booked into this jail, and you get put in a drunk tank, which is a big tank. You know, there's probably room for, in this place, maybe 50 or 60 people. Now, I knew I was not drunk because I knew the quantity of alcohol I had consumed, and I knew the legal limit when I was driving badly, obviously. And then I looked at everybody in the drunk tank who were falling over, and then it made me feel even better that I had a level of comfort that I was not drunk.
Yeah.
At about, they determined that too. So about 4 o'clock in the morning, they let you out. They don't take you to your car though. And
they just let you walk.
This is pre-Uber, pre-anything. This is like a long time ago. No taxis in this particular area. So I had to walk back to my car, went back to my hotel room, took a shower, went to take this depo of the most boring tax guy ever. Literally barely stayed awake, then drove back to LA. Like 2 weeks later, I get the results of they take the test. And I think I was like 0.01. So 0.01 is the lowest reading you could have after having consumed alcohol. And nothing, that was it. That was done. Nothing happened. And I knew I wasn't. but it was an interesting experience. And I tried to take in everything during the experience because I wasn't really seriously, I was not concerned I was going to get anything negative was going to happen. So I hope that taught everybody a lesson. So JR, now I've told you, don't let it happen to you. All right.
Whew.
But before we go on, are you all right? You're okay?
Yeah, of course.
Wow, we haven't even got to this part yet.
Maybe I should have looked at the topics before we started.
If you're this is a question for you. And I, by the way, you have to be careful here. You really have to consider what I'm saying very carefully. It'll be more entertaining for you. So if you're opposed to something, that means you're anti, right?
If you're opposed to something, that means you're anti.
You don't have to answer. That was rhetorical. If you're for something, does that mean you're uncly?
That was stupid.
I agree. I agree. Now this requires close listening. How many flies does it take to screw in a light bulb? I said it a particular way on purpose, by the way.
I don't know.
Two, it's just hard to get them inside. Yeah. So, did you hear what I said?
Yeah.
Okay. And last, this is embarrassing. Another embarrassing story, but I got caught taking a pee at a local swimming pool last week. The lifeguard yelled at me so loud that I nearly fell in.
Oh my God.
Okay. All right.
Yes.
All right.
Yes. Dude does need help. Thank you.
All right. If I say Jerkessi, what comes in your mind?
The SEC 10b-5 is going to be found to be the only way they're going to be able to enforce is it in federal court. That's what comes to mind.
What comes in mind is that I didn't even know if that's still the correct pronunciation of this stupid name. So
Jerkessi.
We don't know. The attorney knows if it's a correct.
Well, we can assume so. I mean, he does represent the guy, right? You would have thought that he would have had to have talked to him a couple of times.
He spoke very confidently about his name.
Yes.
Yeah, and everybody else did not. But we did comment. We did a couple live streams on that oral argument. What kind of looking back? What was your kind of thoughts about the oral argument?
Well, I thought SEC's attorney, the government's attorney, his rebuttal was actually the most cogent of his whole argument. I mean, his biggest problem was he had more of the more vocal judges asking questions. So, he got through, they give him that first, I guess, 5 to 10 minutes to talk about their argument without being interrupted. But his questions were more laser focused. He had the tougher question. Well, I don't want to say he had the tougher questions, but he had the if
you listen for a couple months, it's possible.
I think the government's attorney got the more laser focused, difficult questions. But I think the most difficult question was to defense counsel, and that was, when he said, if we rule more broadly, what's going to be the impact of this? And his response was, well, I don't know. I'm an SEC expert. And she said, I know that, dummy, but I want to hear what you have to say about how this is going to impact more broadly. And he couldn't give an answer. He had no answer for it. And I think it's because, well, let me rephrase that. He had an answer. He knew what the answer was, but he knew if he said it, there was no way in hell that they were going to rule that more broadly. And the only way he wins is if they find that 10b-5. The only way he wins is if the court takes a narrow view and finds that 10b-5 really is similar enough that it's considered common law fraud, and thus it kicks you into the Seventh Amendment. That's
Yeah,
my
and
take.
so just to clarify what Jerkesi is, so that's a case involving where after an SEC proceeding, Jerkesi sued the SEC and they prevailed on appeal. The SEC took it up to the Supreme Court. The Supreme Court is now determining if, in a case involving I'm trying to be as narrow as I can, and in a case involving a 10b5 or fraud claim where there's money sought by the SEC, does the defendant or is the defendant entitled to a Article 3, which means a particular federal court designated by the Constitution, where the judges are appointed for life and they're powerful. So are you as a defendant, in this case Jerkesi, are you entitled to a jury trial in front of an Article 3 court where you have full evidentiary protections and everything else, as opposed to the system that the SEC and FINRA operate that provides less,
Right.
at best provides less. And so that's what's being decided. The question is, how broadly is it going to be decided? Is it just going to be narrow about a fraud claim and these facts, or is it going to be, all common law claims? We don't know. But it certainly, I was kind of surprised somewhat that the justices went right to that right to a jury trial. There was 3 issues. They ignored 2 issues. They went into 1. That's it. That's all that was discussed. Kind of looks like everybody had kind of figured out that was it, and it was going to be tough. I think, based on hearing everything, I think the government thinks they're going to lose too.
Yeah.
It just means to what extent, because if they're able to kind of carve the loss so it's really narrow, they will perceive that they did as good a job as they could. But it seemed like in the argument that they're expecting not to win.
So let's talk about the slippery slope we're on, though, because even if they keep the case narrow and rule that 10b5 triggers a Seventh Amendment jury trial and under an Article 3 court, what then is the next step? What's the next thing out there? Because now this case can be used as precedent. And so there's multitude, and not just with MMTLP and securities, the broader issue, because there's a multitude of statutes that are not common law that are similar to fraud. When you try to defraud Social Security, so does that mean if you try to defraud Social Security and the Social Security Administration wants to come after you, now you have the right to a jury trial in an Article 3 court. The FDA, the same with the FDA. I'm certain there's very similar statutes out there where they can charge corporations or individuals for committing fraud under Food and Drug Administration regulations. So that's the slippery slope that we're talking about. Even if they keep the decision narrow, is that now you've got this case out there that sets precedent in terms of 10b5. So if you have a similar statute, it follows then that statute that's similar to 10b5 throws you into a jury trial.
Somebody asked for a bad joke, so I was going to say, since you mentioned it, how do you pronounce FDA?
Huh? How do I FDA?
3 letters. Come on, buddy. Get with it. All right. To explain what JR just said, because he speaks way above me, to be honest. Sometimes when we're talking, we have conversations regularly. I pretend to understand what he's saying, but I have no idea, because I appreciate it, though. I very much. He thinks about things a lot more in depth than I do. So I appreciate his consideration. So the way it works is going back to how the hell do they figure out what kind of claim is entitled to a jury trial versus a non-jury trial? So they make up this ridiculous standard. If it somehow is a claim that was made in 1791, no matter what the name you're calling it today, that's a claim that's entitled to a jury trial. Unfortunately, they have not defined what those claims are. So it may be very well in Jerkesi involving the SEC that they're going to start calling out what those claims are. And over time, probably the majority of the claims that are brought involving the SEC will end up being brought in federal court. Because it appears that the court is intent on reducing the authority of regulators. And so consistent with that, you would expect, and that's what the government seemed to think by their argument in this case. So I think it's going to be limitation. Now, I don't think, so I did a video on this. I talked about inaccuracy in legal headlines. So JR, the timing was interesting. JNR and I did a live stream early. We watched the first half of the oral argument. Then we watched independently, we watched the second half, we talked, and then we did a second live stream. In between, when I watched the first and second, I saw this article that must have read or watched our first live stream, because it basically it made a determination the same way that we did. But what concerned me, and this is the problem I find in headlines, and this is why I suggest for people to be critical, skeptical, not only when they read the body of a article or publication, but especially on the headlines. Because oftentimes the headlines are written by somebody different than the person that's writing the article, and their intention may be just get people to read it. So in between, I saw this, and it annoyed me, by the way, because I think it's inaccurate. It says, U.S. Supreme Court signals it could limit SEC in-house enforcement. I don't see that. I don't see it that way.
No.
That's way, way too broad.
Well, here's the other thing. But let's laser focus on that, because that tells me that those people that wrote that article weren't listening with a keen ear to oral arguments. And you know, because you and I talked about this, defense counsel basically said they've already limited it. They only have 3 ALJs in-house.
Right. But it concerned me again that the articles were just not, I mean, the headline.
Not accurate.
It's not accurate. It's, as much as we'd like that, and eventually it may, like piece by piece, I think I described it like the petals of a flower, right? They're going to pull one by one. But this kind of seemed like over the top. And again, even though I liked the headline, it gives me concern about the news media's portrayal of legal issues. And at the same time, I saw they did 2 on Tesla related to their autopilot. And we're going to get back to the normal flow. But I just thought this concerned me. Again, because we can look at it, we can kind of decipher it going through it. But somebody who doesn't have a legal background, they're easily going to be confused by it. And it's probably intended to be confusing.
Sure.
Or to drive a point of view. But this headline says, judge says evidence shows Tesla and Elon Musk knew about flawed autopilot system. There's another headline by another agency that was similar, but different. Now, if you read that headline, you'd think that the judge determined that there had been certain facts adjudicated. So there had been kind of a determination that Tesla or Elon Musk knew something. When in reality, this is just emotion. And the standard on emotion is a dispute of fact. So what actually happened here is both sides filed briefs. There was a dispute of fact, so the court could not grant the motion to dismiss that Tesla made. That's the conclusion. Now, what they wrote as a headline, I do not know where that comes from, but not very similar to what I said. And these are legal headlines. So the reason why I point these out is I know they're wrong. So right. I don't know every headline. I'm not an expert in everything, but I presume that the inaccuracies that I see exist in all kinds of other areas that we're reading. And everybody just be super careful, because it can sway opinion. And we know, because we saw it, that for arbitrage purposes, there may be algorithms that pick up wording and act on wording, and
Right.
it may be to have a stock sell off. We've seen that happen, right? Capybara, when they did their first one, there was a huge, like a 45% drop that one day,
Sure.
obviously in connection. So that was false. I mean, it appears to be false. And I know there's litigation that's ongoing about that, but it has an impact. And I'm just urging everybody to be super skeptical and critical without being paranoid. I don't think you have to be paranoid, but if something's not true, just point out it's not true and deal with the truth and move on. So we're talking about Cherkasy, and we're back to Cherkasy. And one of the things we were talking about, we talked about privately more so. I brought it up, but you kind of thought about it. We talked about it off the air. Was the private versus private? Do you remember that discussion that the two liberal justices kind of like,
Right.
they said, if it was private, that would be a much harder call for us, but it's government, and government can do this and this, and so whatever. Why don't you tell me what you think about that?
Well, that goes back to what we talked about, I think, because I was giving it more thought. That goes back to this whole FINRA and this this notion that you're forced into arbitration. And part of what the court was talking about there was, if it's private, you always have a right to a jury trial. But if it's private versus public, then it's questionable because of the way Atlas Roofing looked at the Constitution and interpreted it. But our conversation was centered around, well, we know FINRA is private, and if it's a private company or a private entity versus a private citizen, or a private citizen versus a private citizen, or a private entity versus a private entity, you always have a right to a jury trial. But we do not have a right to a jury trial because we're forced into arbitration by FINRA. Now, part of Alpine's argument is that FINRA is a state actor. And so this, I think, the more that I thought about our conversation, this becomes a double-edged sword for FINRA, because on one hand, they've got to argue that they're not a state actor. So if they're not a state actor, that means they're a private entity, which they want. Okay, that's how they want to be construed. But that's a double-edged sword for them, because then I think if we assume that that Atlas Roofing stays intact, and if we assume that the court elaborates on this private versus private in Cherkasy, then I think there's an argument to be made that, well, I am losing my right to a jury trial, because we know that in order to be a FINRA, in order to be a broker dealer and have access to the retail community, you've got to be a FINRA member. And if you've got to be a FINRA member, the arbitration clause has to be in your terms of service. So I really don't have a choice. And now you have a private entity that is forcing my constitutional right away. So I think, as you and I talk, the more we kind of talk through this, the more I think there's a strong argument to be made that they are forcing us into arbitration and we are losing a constitutional right. And I think that's in conflict with what we heard during the Cherkasy oral arguments. Now, whether or not that gets elaborated on in the opinion, there might be some meat on the bone there to use if someone was so inclined to move this through court. Do you know such a person?
Well, excuse me. I'm involved in an arbitration with Fidelity that's under the guidance of FINRA, and FINRA administers it under FINRA's rules. And as it turns out, our arbitration hearing date is June 17th. That will be, I think, after a ruling in Cherkasy. I think if the court grants relief to Cherkasy in any fashion, I think I would have an argument to be made in my arbitration. I'm certainly going to make it. Before we start, I object to this proceeding going forward. I want to take this to federal court. I'm entitled to a jury trial. Thank you very much. That's the argument I will be making. And I think there's a good chance that the court is going to rule, at least in some fashion, in favor of Cherkessy. And kind of I'm going to take you one step farther. And by the way, this is kind of like bigger stuff for all of us because it may not involve our individual ticker when we're talking about it now, but it may involve the market in the grand scheme of things, and that will influence us all and affect us all. So a couple things I wanted to mention. So you mentioned Atlas Roofing. Just to clarify, Atlas Roofing is two things. It's a case that got decided like 50 years ago that apparently said to the effect that if the federal court, if the government was seeking a fine, that they could do it without providing a jury trial. Atlas Roofing also is a roofing product, so hopefully that's doing well. I do not know about that. But the case apparently is surviving, and if you listen to that oral argument, it was probably mentioned like 100 times by that was it. Atlas Roofing.
Both attorneys.
It was annoying.
It was Atlas Roofing in the two
Yeah.
subsequent cases.
Yeah, whatever. Carnivera and Chicken Little. I believe those were the two other cases. But the justices asked also, and but anyway, so that's one thing. I think a big issue that FINRA and all SROs, because that's the whole point here, is this applies theoretically to not just FINRA, but anybody who's a private corporation acting as a government agent who has immunity, right? So FINRA is a private corporation. So to explain what that private is, so the way it's set up is the liberal justices distinguished between the government and a private party. So in that case, the SEC is the government and Cherkessy is the private party. So they said under that circumstance, the government can do what it wants, basically. That's what they said. But they kind of volunteered, and I didn't understand why they did. It was either they were sloppy, they didn't understand the subject matter, or they have a game plan that they're already executing. But they said if it was private, then the argument about a jury trial would be much closer and a much more difficult question. And so the private in this case is FINRA, who every pleading they file asserts they're a private entity, and Alpine, for example, Alpine in the GTII scenario. In that case, you have private. Mm-hmm. And Alpine is complaining. And, again, just because they're complaining and right doesn't mean they will succeed on the appeal. So Alpine's on a Alpine GTII. Back to that stuff. Alpine is the prime broker. GTII is the ticker. And there's an appeal pending. But the appeal is on the injunction. I know this is going to sound bizarre, but the appeal is on the injunction. So even though Alpine may have the correct argument, they may still lose because the issue is the injunction. But there's two other cases pending also in the DC Court of Appeals that are similar that might also go up. And the question then would be, if FINRA, a private company, is going after a private individual for any kind of fine, does that private individual have the right to take it to federal court? And if they find in an SEC circumstance they can, for FINRA, I think they'll find that absolutely. It makes less sense for FINRA to be protected, especially they say they are a private company.
Well, that's the thing. That's their biggest hurdle to get over. They're and that's why I said they're in a catch-22. because on the one hand, they're arguing that they're not a state actor and they're a private entity, but then that throws them into, you're being thrown into the whole Seventh Amendment issue and the right to a jury trial, which they haven't been providing.
Well, I think it goes beyond that. And I don't really think they've thought this out, honestly. I think they're risking their immunity status. If their assertion is they're a private company, they make no bones about it. What there is no rational reason, there is none, for
I
them
think,
to get immunity, because whatever liability they are protected from, they could price in. And if they're not competitive in their pricing, then let them get somebody else to manage the system. This is a contractor, probably
well,
they're an outside company. It can be done.
but you're right, it could, but go back to why FINRA is here to begin with. All right. FINRA was the combination of two independent regulators that were doing this role. And during 2006, 2007 financial crisis, Congress deemed it necessary to combine them into one entity. Now, now I get what you're saying. Is there another way to do this such that it's they're competing with each other? But but we know that the SRO model is not working in this instance. We know
I
it's
don't
not. We don't need to look at any of the court cases, and we know exactly why it's not working.
just
Whether
think,
it's
but just think if in the MMTLP situation, just presume that FINRA, private company, gets sued by me. Oh, they did. That's right. And the reason why I couldn't pursue it is because they were immune.
well, the issue here is regulation and oversight. That's the big thing. And so the question becomes, does it make sense to have an independent private entity that has immunity have the oversight over basically the financial providers, retirement providers, the broker dealers? Does it make sense for a private entity to have oversight over them? And the answer is no. It's no, and it's no for more basic reasons than we've even discussed tonight. It's no because it's the it's the fox watching the hen house. That's I mean, all of these people are coming to FINRA out of the industry. They're accountable to no one because the next guy above them comes from the industry and the next guy above him comes from the industry. And we know, based on Gary Gensler's testimony, that they're not watching these guys. We know that they're an independent operating organization that's not being watched.
I'd be open to, that's interesting, by the way. I'd be open to a qualified. So they have absolute immunity. So no matter what they do, they could be running like, I'm just using this as a off the cuff example. They could be running, like a drug ring, and that's okay. Whatever, they're protected. So to me, protection for fraud, intentional misconduct, there's no logic to that. Protection if they make a mistake in good faith because they're a quasi government and we're going to give them a break because they're making less money or something like that.
Right.
Maybe for negligence, if negligence in good faith, and if somebody does it twice, sorry, at some point in time, they probably should be terminated if they can't do the job. But if it's not, intentional, then okay, I could see that as being something that should be protected. But we're talking about fraud, right? We're talking about like all these are corrupt acts. There's no reason that, let me put it this way. If the DOJ is investigating this stuff and the Secret Service, there should not be complete immunity for anyone who's involved.
No, the immunity is it's just their icing on the cake. It gives them free reign to do what they want. What they should do is wipe out the first three layers of leadership at FINRA, and those should all be government employees to answer to people at the SEC. And they should have far more congressional oversight.
Yeah, I have a different view.
Far more congressional oversight than we have.
Yeah, my view would be that the company, I don't mind if it being a private entity being outside, but that they don't have absolute immunity. And that if they screw up, they screw up. And if they want, and again, they can make that whatever they think their perceived extra liability is, they'll charge. They'll
They'll
raise
charge.
they'll raise their fees to the SEC, however it is.
That's right.
But I don't think they should be free. And certainly if they screw up enough, they should be terminated. It,
Well,
it,
and
it
here's the thing. Let's just take the 36,000-foot view that we know they screwed up, because look at all the congressional letters that have gone to both the SEC and FINRA, and not one of them has been answered.
You're referring to
You know,
MMTLP, correct?
going back to MMTLP. And so that's, I mean, that's not the only reason we know they screwed up, but that's certainly number 3 or 4 on the list. And it's something that needs to be looked at by Congress. Why has this organization that has oversight over 105 broker dealers, that has the authority to promulgate rules and regulations, set fines, act as judge, jury, and executioner, not have to be responsive to Congress?
Yeah. And this is my JR has heard this a billion times, and I've stated it a number of times also, but it would be nice if Congress used all powers in its possession to get the records and information they need. I don't believe that they've been able to get everything that we would like to see on MMTLP and maybe other stickers, that are out there. And the magical power. And I was thinking about is, the magical power for all of Congress, Senate, House, is subpoena power. And I'm an old guy, and so over the years I've seen them use it, but it is sparingly. Like when they did like the Nixon impeachment, that kind of stuff. So it was big stuff. And as a lawyer, we use subpoenas like it's a common thing. It's no big deal to get somebody bound to give us either information or testimony. So for us, it shouldn't be difficult. But I understand that Congress views it differently. And it's frustrating when I believe that it'll be difficult for us to get the information we need voluntarily, and that they're not using the subpoena power. So I said that about as nicely as I could. I feel super strong about that position. And it's not like I don't appreciate all the congressional people involved and everybody's doing their thing. I do. But I know from my personal use that a subpoena is really impactful. And if you have one, once you deliver it, you're entitled to a response, and you have an ability to enforce that. And until that, you're kind of waiting for
Right.
the good faith of somebody.
Right. Well, I tend to take a more pragmatic view. I mean, look, we know Congress is slow to act. That's part of the legislative process. And some of that's by design, based on the Constitution and how Congress as an institution functions. So what is an appropriate amount of time for them to act in a situation like MMTLP and market reform? Sorry, someone was texting me and correcting us. I'll take a look at that when I get done with this thought. So, crap, I forgot my thought. Oh, it's a process. Again, some of it's by design under the Constitution. Some of it's by design because how Congress functions as a whole. When is enough? When is enough enough? I don't know the answer to that, and it's being asked quite often. Uh, but going back to all these letters and the lack of response that we've seen, again, those letters and support from congressional offices are just a turn of that vice. Every letter that's gotten, no worries. Now he's texting me, I'm sorry because I lost my train of thought. Every every one of those congressional letters, whether it's a very stern one or whether it's a very generic one, it's just one more vice turn. It's just one more vice turn.
It would be, again, I know that people believe that they want the priority for MMTLP, and I think it's got a unique position. But I haven't understood why every other ticker that's in the same position, why haven't they done this? I mean, they have a model now. The MMTLP community created a model, and
Well, I don't think they can. I don't think they can, and here's why. Because we've said this multiple times. The unique thing about MMTLP, and I'm going to quote, I think it was John Berta's words or Wes's words. I don't know who said it, but the quote is, "It's frozen in time." There's no argument to be made here. There's no, well, it's traded. There's just
I
none
know,
of that.
yeah, no, I
Frozen in
know
time.
that, but there is a lot of shenanigans going on with other tickers. We know
Well,
that.
but that's it.
Listen,
It's the shenanigans.
yeah, I mean, so why? I would think, by this time, because it's been public that there's been a response on MMTLP. It's not like that's a hidden information. I'm just surprised because there's a lot of people in the other tickers, AMC, GME, all those. It's probably like millions of people in those. And can you
But
imagine can you imagine the uproar that would be caused by
well,
volume, by
there
volume?
there's definitely no two ways about it that it would be an uproar, but I don't think it would be as impactful.
Maybe not. Maybe not.
Someone like James Angel could have walked in there and said, "This is all nonsense. It's actively trading. It's just volume
I know.
fluctuations and vol." I mean, they really could have thrown the kitchen sink at them, and I think it would have stuck.
But at some
Whereas
point in
with
time, it becomes an election issue. So if there's enough people complaining, then they consider how's that going to impact the election. And so that's why I believe, MMTLP. I hoped, and now we have one extra, and hopefully more to come. But I wish I think there were like 65,000 shareholders purportedly. That's kind of the number we had at one point in time. I don't know if that's true, and I don't know if that's individuals. But wouldn't it be nice if there was like 1,000 arbitration claims filed by a bunch of people?
you've said that before.
I know I have. I said it again, but I think it would be very impactful and justified. I know it's difficult, by the way, and costly, etc. But
Right, and but
go ahead.
they bank on that. That's what they bank on. They bank on people not acting. They
Yeah,
bank on people, the deer in the headlights reaction.
yeah. Well, for
Because
most people, and I understand it, it makes sense because it's complicated. Listen, we're a year in, right? And we've been pushing the whole freaking year, right? And through legal stuff, non-legal stuff, whatever. So it's difficult. But again, nobody's going anywhere, right? We're a year in. It's just another day in paradise. Tomorrow's just another day. I think, and again, I think their defect in their strategy is they thought at some point in time this is going to end.
sure.
And I don't think it's going to end until it's resolved.
Oh,
That's
well, no, we know it's not. We know it's not. I mean, look, I think the next piece of good news for people is going to be the FAQ response when it does get published, which I would imagine it's going to get published here soon. So people and well, let's take a step back on those FAQ response, because do you think do you think in FINRA's mind that they ever thought that they would, that a community of people on Twitter would respond to their FAQ
I
and
want to know, has anybody done
basically
any research if they've ever done multiple FAQs on
no, they
any
haven't.
security?
They
I
haven't.
guarantee no.
They have not.
No.
And certainly no one has ever questioned them publicly enough to make them have to respond with a second one or a
The
third one.
third one. Yeah. Yeah.
So they're either doing one of two things. They're either scratching their heads going, "Who are these knuckleheads?" or they're shitting their pants. And
Or a combination.
I tend to think it's a combination of both. And the other thing that they didn't anticipate was just the, and I go back to it, that whole congressional movement that people are doing. I mean, they send James Angel in there. That's standard operating procedure. He puts on a really fancy PowerPoint, with, oh, it's all market mechanics, blah 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 blah. And where are the James Angel? He's gone. I mean, he's just gone. So this notion that things are not progressing or things are moving, they are. We know they are. I know they are. So again, it's only a matter of time. You and I talk about this all the time. We've talked about that right from January. We had a sense that it was a matter of time. We both, I think we both can say now with a level of certainty that, back when you and I first started talking, we knew it wasn't going to be resolved this year, but it's going to be resolved.
Yeah.
It's
We were
going to be.
hoping, listen, we were hoping, but we kind of knew that,
We knew.
it would be unusual. And again, when you're dealing with, this is kind of like, unfortunately, the practical part. If you're dealing with a bunch of scumbags, I love that word, by the way. When you're dealing with a bunch of scumbags and they've acted in a particular way, you shouldn't expect them to act differently. So,
Right.
They're not going to throw in the towel. They're not going to just bow and say, yeah, we were wrong. Let's settle it today. So we kind of expected it would take some time. How much time, we don't know. That's kind of like guesswork. But I know there's been some projections of resolution of MMTLP. You've seen those time frames, and you and I discussed those time frames throughout. Just like we said, we'd be surprised if it was in the first year, because we were. I mean, we discussed other time frames. But I don't know about now. So you heard like there was a 60-day. So we're like 10 days into that 60-day period, you say, about?
Yeah, look, I have a lot of respect for Mark as an attorney. He knows that. I will tell you, though, I'm not quite sure where he's getting the whole 60 days thing, but hey, kudos to him if he's right.
Yeah, that's a good point. Because if he's right, that's something we don't know, and that's great. That's wonderful.
Well, I think Drew. I think Drew. I thought Drew was on a space the other night too, and he made a comment that he's been saying something similar since before Mark. Now, I'm not doing that to point out the conflict. I'm just doing it to say that there's multiple people now that have said such a thing. My optimism remains the same. I know it's going to be resolved. It's going to be resolved. I'm reluctant to put any kind of time frame on it. I won't. If you wake up tomorrow and it's resolved, great. If you wake up 59 days from
I
today,
will.
great.
I'll put a time on it.
I'm not.
Okay, I will. I will. So, I don't. If it happens within 60 days, that would be tremendous. I just, I would think though, it's a complicated resolution that have to be documented. There's probably difficulty in locating people. There's going to be some amount of people that you're not going to be able to locate. They're either going to be dead, they're going to be new address. Right. So you're not going to be able to close it right away. It's not going to be like you'll push a button and it's done. You'll need some interaction because somebody's going to have to sign a release at some point in time. And
well, that's important. That let's focus on that, because there was a comment made the other night about any kind of resolution is going to require us all to sign NDAs, and Drew had come out and basically said that that's nonsense, and he's 110% correct. NDAs are not an appropriate remedy for something like this. No. It's what you just said.
Yeah.
And what did you just say?
Yeah, so let's explain. Are they going to ask you to release your claims? I would expect them to, because if they don't, I would think that's malpractice on their part, because they don't want to pay you X dollars and then get sued and pay you X dollars again. They don't want that. Right. So I would expect that they would require anybody they pay money to sign some type of release. It'll be some standard document. And, I'm sure when it comes out, guys like us who might get the similar document would take a look at it and probably opine about our own document that we have. But that would be expected. In terms of, now you're talking about an NDA, a non-disclosure agreement, and then you could talk about a confidentiality agreement. So those could all be separate agreements. They could all be a paragraph or two within a settlement agreement, because they may be like an actual settlement agreement. It says we're going to pay you $2 billion. You give us all your interest in MMTLP. You release us all claims, and we all go our separate ways. Something like that. Were you going to say you were going to say something?
No, that's exactly what I would say. It'll be a confidentiality clause.
Yeah.
You won't be permitted to talk about it, and there'll be a release of all claims. Because to your point, the last thing you want is to settle it and then have everybody turn around and go through arbitration. That I mean, that those are standard things. We know that's going to happen if there is some type of settlement.
Yeah, you would expect that if they, and we're talking about MMTLP, you would expect, and again, so I'm saying if I was the lawyer and I am bad guys and I'm saying, okay, we're going to pay everybody $1 billion, but they got to sign a release and a confidentiality agreement, I would probably require that. And most people, this is just general. Does anybody have to sign anything they don't want to? No, they don't. If you don't, but it's a condition of getting the money, then you won't get the money that other people might. You'd still have legal claims and you could pursue those legal claims. But generally, most people will sign within reason, giving up their rights, understanding that's kind of what the exchange is. You give up rights and they give you money. That's kind of it. So that's kind of to be expected. But any kind of beyond that, sometimes you can sign a confidentiality agreement where you can't speak about the terms, or you can only speak about the terms to your accountant or your tax person or limited people, those kind of things. All that might be on the table and it wouldn't be unusual or unexpected. Right. Do you want to add anything?
Well, I was just going to say that's why you and I, when if you remember very early on, there was a lot of talk of the gray market. We're going to start getting, your broker's going to start calling you to buy your shares on the gray market. And if you remember, you and I had the conversation around this. No, they weren't. And the reason they weren't is because they stopped this thing because they knew there was a problem. The last thing they want to do is have broker dealers start calling individual people, which, by the way, we're already talking on Twitter almost immediately after the halt. There's no way to keep that confidential because the first 100 people that are going to get a phone call are going to be gone out there running their mouths, and knuckleheads like us are going to be talking about it. And we know what they're going to be calling for. So there's no way to call and say, we want to talk to you about these shares, but we have to put you under an NDA in order for you to discuss. Well, they might as well hold a guilty sign on their back at that point. So there was no way for them to do that without basically announcing that there was a problem. So I never, not even once, did I think that was going to happen. Now, could it happen to larger shareholders? Well, it could, but we would have seen it by now.
Yeah, with me, I find it, and JR and I have talked about this also. With me, they've specifically said, we're not going to pay you any money.
That's right.
Yeah, I mean, they've been pretty clear. And
that's a telltale sign.
I found that like really shocking. Because we've talked about this. I would think that, again, just see if he'll take $1.49 and be away, because he's an annoyance if nothing else, and he's a cost.
Well, he's a huge cost. You are a huge cost.
I want to speak in the ninth person if I can. I don't know what the verb is though. But I'm shocked they haven't tried to make me go away. It's been surprising to me. And then that initial hearing, the language the attorney for Fidelity asserted was they weren't going to offer me diddly. That was pretty clear. And it was interesting because I'd heard other people had gotten offers, right? You've heard that talk. Right. People who got.
Oh, yeah, I've heard it, but I put zero stock into it.
Yeah. So I'm saying, I don't have any. I don't believe this to be. I have no firsthand knowledge of any of this stuff. I don't think I've ever spoken to anybody who's told me they got an offer of a certain amount. But I don't know. I've heard like people being offered sums, maybe people with really certain large amounts of shares, but I've never heard about it. And I would expect me to be somebody that they would, again, why would you want to take, listen, if nothing else, I have a bunch of discovery requests. Why, Mr. Opposing Counsel and Ms. Fidelity, or infidelity, depending on which you're thinking about, why would you want to risk it? Why? What's the what? And again,
Well,
they may come to me and say, offer me $1.46, and I may say no, but I might say yes.
well, I don't even think it's about the risk. I mean, the cost basis, the cost benefit analysis on this on their end is through the roof. I know
Yeah,
that.
yeah, yeah, yeah. It's shocking to me, and it'll be interesting. I'd be interesting to find out what the strategy is as it applies to me in particular. So maybe JR can make it up, and we'll have a great story. I was going to go back to Alpine and briefly kind of talk about what the impact would be, because so Alpine is GTII, and so on one hand we're talking about that maybe FINRA is going to get schooled at some point in time. Maybe first it's going to be a limitation on what kind of proceedings they can have in FINRA, which I think that's going to be the first. But maybe there'll be another case that'll go up. And I think, by the way, this would be 24-25, Supreme Court term 24-25, not before then. It'll because they've already chosen the cases for this year and where they're playing out right now. But maybe in that term also, there might be a case where somebody like me is challenging the immunity of FINRA. Why not? Why not? Especially if I
I
have to
mean,
go through the stupid arbitration.
I think a lot of it's going to be dependent on these cases that are working their way through the system, and depending on the breadth of Jarkowski, damn it, depending on you know how the court rules on that, whether they rule narrowly or very broadly, will have a direct impact on the Alpine case. And then at that point, I think reviewing those opinions and I think there's going to be an argument to be made there. I really do.
Yeah, and so the bottom line though is in terms of how the outcome will affect the inevitable, that's I just made a conclusion, a demise of Alpine. I don't think these cases have anything to do with that, because I think in the end
No.
Alpine's going to get kicked out. That the enforcement mechanism, whatever it is going to work. What we don't know is who's going to be the one that's going to be kicking them out. Is it going to be FINRA in their judicial system, or is it going to be in the federal court? That's
Right.
really what the question is. And I think Alpine, if I were, and we kind of talked about this, if I was Alpine's counsel and I was listening to that oral argument, I would have not been pleased by the discussion. Because on one hand, it's fine, the issue about that maybe the proceedings and enforcement of FINRA is being challenged, but there was no reference anywhere about Alpine being excused. That was like completely irrelevant to the case. So if I were Alpine's counsel, I would think in the end that it's going to do me no. Ultimately, it doesn't change my position. I'm going to still have whatever I have, all these enforcement actions. I'm going to get expelled. It just depends on what the process is.
Yeah.
That's all I
Well,
would try.
it's buying them more time. I mean, if they get granted, if they win and they, make the argument that FINRA needs to go through an Article 3 court, it buys them more time. But the evidence is so overwhelming. How do I just don't think they can win.
Yeah, not financial advice by me. But I would think, if somebody came to me, so the way it works is maybe there's analysts who will look at that case and they work for Goldman Sachs and they'll give them an opinion about how it impacts the value of X, Y, and Z. So in my mind, I think that was a loser, that oral argument. I think that's a loser for Alpine. And if I were giving intel to a broker or a hedge fund, I would say their position is worse and they have more risk now than they did before the oral argument. And I don't know. So that would be me. And I don't know if that goes on, but I would expect that there must be analysts who do that. And could that be translated? Well, one, is it interpreted the same way that I just interpreted? I don't know. But if it is, could that have an impact on the value of the stock? Could it cause buying or selling? Perhaps. I don't. We don't know that. That's kind of like guesswork. Like by now, we all know that like timing the market, when anything's going to happen, if anything's going to act rationally. If you do X and you're expecting Y, does that always happen? We've already seen that doesn't necessarily go that way.
Yeah. Yeah. I mean, we know that.
That's a brilliant addition.
I have nothing more to add.
But what ultimately is going to happen is I don't think it's going to end. It's going to stop Alpine's demise. But it'll be interesting to see if FINRA loses the powers, and it'll be interesting to see if eventually FINRA loses immunity or some amount of immunity.
Nice.
I think by the way, that's the solution. I believe if you kind of look at all our problems to date, so we could use MMTLP as the marker. If FINRA had no immunity, they'd be sued. Discovery would ensue. Documentation would come out. It's done. It's done in that case.
Well, that's a way to hold the. Yeah, I mean, if you hold the top of the head of the snake accountable for the rest of the snake, the rest of the snake's going to fall in line. So to your point, maybe one of the solutions is remove their immunity.
Yeah, because then, as long as then they're at risk and they have direct responsibility, and there's also the right for discovery. Because isn't that the thing that's been clamored about? I mean, the whole reason you have to generate so much effort through Congress is because you don't have really an independent means of acquiring the documentation.
No, and it's documentation that should be public. This is a publicly traded company. All that information at the end of trading should have been publicly available. End of story.
Yeah, I mean, I don't even understand the logic behind.
Well, it's to hide the crime. That's because they can hide the crimes.
Well, no, we know that, and it benefits somebody financially, of course. But in terms of like the public good, there's no reason that this shouldn't be absolutely transparent, unless there's bullshit going on, which is right. And that's, we obviously have seen that. So
I think one of the ways you could solve this problem is to allow an issuer of stock at least, twice in a 12-month period to say to the exchange, halt trading, and we want an immediate share count right now. Halt trading as of, Monday, 4 p.m. We want an immediate share count, and they have to produce it. That would fix things, right?
Yeah,
that would fix things pretty damn quick.
Also, for the bad actors like Alpine, shouldn't there be like a maximum number of times you're penalized before you lose your ability to do business?
Exactly.
So in my mind, the number I'd do 38. You have 38 chances. If you get penalized the 39th time, you've had a fair opportunity. I use 38 obviously because Alpine had 40 before 2022. And again, I always find that amazing and pathetic. If anything showed the defect in our regulatory system, it's Alpine's existence. But what can happen, notwithstanding what we talked about, perhaps the Supreme Court will limit FINRA, and that would kind of be theoretically shaded to Alpine's benefit, but then Alpine has to face the charges in federal court. That's all that happens. So it really doesn't change the position that Alpine would be in. But for the system, it makes a dramatic change, right? Because ultimately, I think it'll end up changing how the SEC and the regulatory system, at least the financial regulatory system, operates. I think that's the conclusion. And what you were said before too is we don't know, and we're all stuck since when you open up an account with Fidelity, you sign that stupid agreement. It's like 154,000 pages long, and on page 153,293, paragraph G, which I'm sure you saw, you're stuck with arbitration. And everybody's kind of
Yeah.
stuck with arbitration. So I think really that was kind of the thing that struck me besides immunity was the impact it might potentially have on arbitration. And that's all good for consumers because the more, who likes to go to court other than lawyers? But who likes to go to court? Nobody. But if you have a chance to go to court versus having to play within the SEC or FINRA system, you'd much rather go to court.
Sure. Well, you have more rights.
Yeah.
And you have a right to your peers reviewing the evidence. You have the rules of civil procedure, the rules of evidence. I mean, you lose all that shit in arbitration.
Yeah, and so one thing that, and JR referenced it earlier on. So, and obviously, in any criminal case, and a traffic ticket might not be considered that type some places, but any criminal case, you have an absolute right to a jury trial, which you could refuse. And in civil cases, you generally have a right to a jury trial, absent there's certain circumstances where you're not. Like if you're seeking an injunction or declaratory relief or disgorgement of money, say. But otherwise, you're entitled to a jury trial in civil cases too. But you can opt out of that too in either case. So this is just giving you that right. And generally, you're considered the reason why a jury is desirable is if you're a plaintiff. So if you're the one suing, you will get generally a better recovery and a larger recovery if it's from a jury. That's how it's perceived. Whether that's true in any one case, who knows? But that's kind of why it's perceived. And that's in a civil case. In a criminal case, it's a slam dunk because all you have to do if you're representing a defendant in a criminal case is get one juror not to vote guilty and the case is over. And if you'd had a judge, you'd have one judge. If you were wrong about the judge, you kind of gave up a big strategic advantage to at least hang the jury or to win a case.
Right.
You agree with the case, that one?
Oh, sure.
I did a couple criminal cases, and one was involving in a casino cheating on some Pai Gow poker or something, and three guys cheating. Or allegedly cheating. I represented one. We went to trial, hung jury for acquittal for my guy.
I prosecuted a teenage. I think she was.
I thought you were going to say Mutant Ninja Turtle. Honestly,
no, she was 17-year-old girl. She had stole 19 pair of black thong underwear from Rogue 21 or Rogue 21 or Rogue 21. Rue 21, that's what it was, Rue 21. They had a video of her. They literally found the underwear in the back of her car with all the tags on them. Officer counted them out. She pled not guilty, and I had to go to trial on it. Now it was in family court, so it was the judge, and there were the funny thing about it is what I offered her during the plea deal for her to plead guilty is exactly what the judge gave her as a punishment. So that was my one and only prosecution. That was in the state of Delaware. I'm one for one, and I'm never going back.
All right, good for you. Look at you. 100% conviction record. That's what you're going to be running on, a 100% conviction record. Wow, look at that. Yeah. Hey, so I've done some trials, not 1,000 of them, but enough, and I've had a couple trials where on the jury, and I was comfortable with it, were other attorneys, like multiple other attorneys. And it seemed to go correct. It seemed to be like if it was something that was straightforward, the attorneys were good,
right?
Because they kind of went right runs rates straight at. But there's like people, other attorneys are concerned having attorneys on because they don't know how they're gonna. They're
Right.
loose cannons. Are they going to be like show? Are they going to make a show and show how smart they are, or whatever? But it's always interesting. There are people that do jury analysis. They do mock juries. You know, if the case is big enough, they'll hire people to
Oh,
do,
sure. Put it on.
you
Yeah.
know, like that. They'll spend like, you know, hundreds of thousands of dollars if it makes sense.
Well, if you have a
Uh,
client that can pay it, and then that's the way to do it. You know, if you have if your client has the money, absolutely, and the case is big enough, that's how you do it. That's why money buys the best representation, and that's sad, but that's the truth.
like all stock picks, there's people that say they can pick like who the really good jurors are, and they'll charge lots of money for it. I'm skeptical. All I know is whenever I pick a jury, I think to myself, do I have any idea what I'm doing here? I'm thinking to myself at that time. I have some like, there's a little deeper logic than that, but there's a side of me thinking about the science of picking a jury, and I'm not that impressed with that.
Right.
Um, Anything to add on that brilliantly exciting topic?
Nope. I think we covered it all.
Okay. You know that the guys are going to South Korea and Thailand, right? They're on their way, or they're going,
Yeah.
or gonna go.
Well,
And
I don't know. I mean, I knew they were going, but I don't know if I don't know where, where they're at in transit or if they've actually left or I mean, if I imagine if they're going to Thailand, they'd be leaving in the evening because most international flights leave the country in the evening.
true, good point, good point. But I think they may not be going right now. But they're trying to outlaw shorting in South Korea. They're doing it through June, and they might do it thereafter. And what I found disturbing was the fact that the U.S. is assisting them in their anti-shorting efforts. And I was wondering, you know, is that really make a lot of sense? Does that give me comfort to know that you know, these guys who are completely abrogating their responsibility in the U.S. are going to assist another country? I don't know if you thought
Well,
about that.
as long as the U.S. doesn't send Dr. James Angel, I think there's still hope.
I think Brandon's going though.
Well, he's going to write about the fact that it doesn't exist over there.
Yeah, I would prefer if the U.S. was not involved in that.
Oh, I
But
agree.
it may be the case that there are so many U.S. companies that are involved in the process that that's the reason why the regulators need to be there. One, to assume responsibility, and two, because they want to cover their tracks, I would think.
Right. Oh,
I
yeah.
mean,
I mean, well, they'd want to. Well, I I don't know about that. I mean, look, it's clear the South Koreans are serious. They put a pause on it. They've already come out a couple of different times and said, "Hey, we're looking into this." And so, sure, they're going to send the U.S. regulators over there, but the South Koreans have smart people too. I can't begin to imagine they're going to greet the SEC with open arms and rose petals when they come off the airplane. I mean, the South Koreans are smart people. If it's happening in their country, they know damn well it's happening in other countries too. It
well, I
doesn't
think
take a
they.
rocket science. All they need to do is watch us talk every week.
Well, I would think it would be interesting. I think the companies that are involved. That's what's interesting. They have disclosed that publicly. You know, they mentioned
Companies,
like over 100 companies that were involved. They've mentioned two major international banks. What they are is that J.P. Morgan and Goldman Sachs. Is it UBS? We don't know. But I think that's probably information that the Feds, the SEC, FINRA don't want out there. I would think. So that concerns me that they're there to suppress the disclosure of information, not to
well,
aid.
that's where Ham comes in. If he's going over there, he knows. So
So what?
he'll make it happen. Snap his finger.
All right.
He's going to walk in the room and say, "Look, man, don't listen to them. They don't know what the hell they're talking about."
Listen, wouldn't that be a brilliant strategy also in the United States? They've done it before, just for 3 months.
Yeah.
Just say, First quarter 2024, no shorting. Just for a quarter. We'll see what happens.
Well,
And then after,
they wouldn't be able to do it market wide. The system would collapse
maybe,
because
well,
they can't settle the trades.
that's not my problem.
Well,
Maybe then let's do it
I
the
know it's
second.
not your problem. I'm
Let's
just
maybe
saying.
Yeah, let's do it the second quarter. I'll give them an extra quarter. Uh, I know it's the problem is that they cannot. Isn't that what the whole point is? And
Right.
that's what Ham always talks about. It's a settlement issue, right?
Yeah. That's all it is. It's a settlement issue. They can't settle the trades. They can't stop shorting because to stop shorting would implode the whole market
Agreed.
because the problem's too big. It's no different than the housing crisis. There were a few people that knew. They knew that it was coming. How did they fix it? You can't fix it when you're the bank and you've given out all these loans to people that can't pay their bills. It's too late. What are you going to do to get the money back? It's gone.
It's gone. I agree. Any questions you wanna take? I had a couple more things I wanted to briefly talk about, but any questions?
No, I'm good.
Okay. Um, so Tesla, I told you to watch the Cybertruck, which you did. So Tesla unveiled its Cybertruck, which is a new kind of truck, a new kind of the skin. So the skin on the truck is bulletproof, and it's very durable as a result. Looks like futuristic, maybe like a Back to the Future, DeLorean type look, kind of, if you know what that is. Which, if you're not like as old as JR, you probably don't know what a DeLorean is either. But it has a futuristic look, or at least to me, it looks futuristic, and it's a truck. So they put it on a track. Amongst the things they were showing off, they put it on a track against a brand new Porsche 911 Carrera, and they line them up next to each other, and they're following it, but with a camera. And you see that I guess it's a quarter mile. You see that the Tesla truck beats the Porsche handily, and then when they show the full vision, the Tesla truck is towing a Porsche 911 while it's crossing ahead of the 911. So it's a pretty impressive performance maneuver. But it'll be interesting because if you live in a major city, or maybe if you don't live in a major city, you'll probably start to see these, and they'll probably stand out on the street because the design is very different than customary design. And it'll be interesting to see what happens. Whether people will like them, if they'll be popular, or if the design will, be too off-putting to people. I find it interesting because it's they're going to do it, and starting off, there's enough demand. They'll sell, 1 million or 2 million of people that are going to get it. But long term, we'll have to see if it's something that people are really like culturally or not.
Right.
So, yeah. So when you see it the next time in Hershey, let me know. I know you already saw one. The second one you see there, you'll let me know, right?
I will tell you, I don't care for the design.
Okay.
Looks boxy to me.
But I think it's good because I think it's going to either be people are going to hate it or love it. And so
it reminds me of a Fred Flintstone car.
Okay, that's fine. The way I figured is that people will either love it or hate it, and there's probably enough, and the people that love it, they'll buy it. And I think there's going to be enough people, even if it's like a minority of the world, that'll that's kind of my view. But it'll be interesting if you see it on your road, when you see some weird looking truck, you saw it. So look out for it.
We see horse and buggies here all the time. So
I don't. I see horses, but not horse and buggy.
Oh yeah, there's horse and buggy. I just passed 2 of them here earlier today.
Okay. MMTL arbitration ongoing. We're in discovery. We'll see. There's a second person who has an arbitration. I kind of mentioned this at the start. It's kind of summarizing. We'll see if other people do. It'll be interesting to see how discovery goes. I know the other gentleman has arbitration. He mentioned that discovery has been difficult. On getting discovery has been difficult. So I gave him, or we discussed certain tactics, and we'll see if that helps in generating discovery. And obviously we'll report on that. Last but not least, and if there's any questions that you see that you want to pick up, we'll do that. But I saw this article. It caught my attention. It was this lawsuit involving this attorney who represented the NFL players on the concussion stuff, and somehow he was involved in tobacco litigation also. The amount of money that was involved was like $30 million. It wasn't insignificant. He had a partner. The partner pledged the 30 million, unbeknownst to the other guy, pledged it as collateral for something else, another obligation.
Interesting.
The obligation's now being called. The money's tied up. Lawsuits going on. The attorney who committed fraud, who's disbarred, is, what are you going to say? He got all these people to invest $30 million. What happened? And the company that's the plaintiff loans money on lawsuits. So if you're a good plaintiff, they'll contact you. They'll give you a percentage of money, and they'll basically take the claim or take a portion of the claim, and that's kind of driving it. But it was interesting to see. It was the NFL. It was the concussion lawsuits. It was a lot of money. Some attorney got loose, and that money's tied up with basically a toxic lender. That's kind of how I looked at it.
Right.
We look at it in terms of, the cases that Basile does, all those toxic lending cases. So when I saw this, like the lending on these cases, and that there was a dispute amongst a disbarred attorney involving like mass tort litigation, that just sounds like that's too many bad things going on. Anyway, that caught my attention. I thought it was interesting.
I didn't even see it.
Yeah, I saw it today. Any questions you saw?
No, I didn't see anything that struck out as me that we need to answer that people had asked. So,
okay. Anybody, if you down the road you look at this, anybody sees it and that you have questions or comments, feel free to write them down. We do look at every comment, and we do. We'll indicate, you'll know we looked at it. So it may be the case that something occurs to you or some question occurs to you. We try not to be evasive or unclear, but we may not always succeed in that. But we appreciate you being here and watching and participating. And we'll see you next time. Thanks again. Any final words, JR?
Nope, I'm good.
All right. Take care, everybody.
Take care, everybody.
This is the part that's difficult.